In February 2021, the Association of British Insurers estimated at £2 billion the value of business interruption insurance claims due to COVID-19, which were incurred during 2020. The recent decision of the Supreme Court in the FCA business interruption test case has broad ramifications to an estimated over 370,000 policyholders in the UK. The Supreme Court decision has made clear that the non-physical damage BI policy wordings, which were under appeal, provided coverage for COVID-19 losses. However, despite the two court decisions in the test case, one by the High Court and one by the Supreme Court, there are still questions which remain unanswered, and I will explain why. The business interruption test case was commenced by the UK's Financial Conduct Authority in June 2020, and it included 21 representative policy types that were issued by 8 insurers, who then became the defendants in the proceedings. The FCA selected 3 types of non-physical damage policy clauses for the court's determination as to whether there was coverage for business interruption losses due to COVID-19. These 3 types of clauses were clauses covering losses that were caused by, first, an outbreak of disease within a specified radius, example 25 miles or 1 mile, from the insured premises. The second type were clauses that covered losses which were caused by a prevention of access. So these were the prevention of access clauses, a prevention of access to the insured premises following a public authority action which was taken due to, or depending on the clause, an emergency or danger or incident or injury occurring, this is the part that is important to remember, occurring in the vicinity or within a specified radius of the insured premises. And the third type of clauses were what were called the hybrid clauses, which combined an outbreak of disease clause with a public authority prevention of access to the insured premises. So these were the 3 types of clauses considered by the courts in the FCA business interruption test case. In relation to causation, that is to say, the issue of whether the losses were triggered by an insured peril and whether there was insurance coverage under the relevant clause selected in the FCA test case, the Supreme Court adopted a much wider interpretation of causation for those clauses which contained a 25-mile radius requirement in the disease and hybrid clauses that were under the appeal. And what is the relevance of this interpretation? The relevance is that the Supreme Court held that coverage under these clauses only required that there was at least one occurrence of the disease within the specified radius for coverage to be provided by these clauses for COVID-19 losses. And this was so, according to the Supreme Court, even if the government action was also due to the combined effect of the nationwide outbreak, which was not insured under these clauses. The Supreme Court went further and decided that all the individual cases of COVID-19, which had occurred by the date of any government action, were equally sufficient, since they were combined proximate causes. And where is the conflict? The conflict arises because there were clauses which were subject to the interpretation of causation that was only given by the High Court. because these clauses did not go on to the appeal to the Supreme Court. So as regards the in the vicinity clauses, which were not appealed to the Supreme Court, the High Court held that there was a requirement that the government action must have been solely due to the local, in the vicinity outbreak. But if you think about it, the problem here is that under this interpretation, it would be very rare indeed for coverage to arise, because it was likely that at the time, any government action was taken, at least in part, due to the nationwide outbreak. So in summary, it is difficult to reconcile the decision of the High Court, which held that in the vicinity clauses provided only localized cover, so it was unlikely there would be coverage due to the nationwide outbreak and the resulting lockdown measures, if you compare the decision of the High Court with the Supreme Court's broader approach to causation, which held that each case of COVID-19 within the similarly localized 25-mile radius was a proximate cause of the relevant government actions, and therefore there would be coverage despite the inextricable link to the uninsured nationwide outbreak. This conflict can only be resolved in further litigation. Therefore, we will have to watch this space. There are three additional areas of doubt arising out of the FCA test case, which are likely to require further clarification by the courts in the future. They are first, the trends clause. Second, issues relating to the concept of restrictions imposed. And third, issues relating to the sufficiency of proof of manifestation of COVID-19. So taking the first, as regards the so-called trends clause, which permits the adjustment of losses due to trends affecting the business, the Supreme Court held that the type of trends or circumstances which required adjustments to be made in the calculation of losses should not include circumstances arising out of the same underlying or originating cause as the insured peril. Therefore, in disease and hybrid clauses, for instance, the reduction in trade due to customers' fears of the COVID-19 pandemic, or any other broad effect due to the nationwide outbreak of COVID-19, should not be taken into account, as opposed to the specific instructions to close certain categories of business. Any nationwide effect of COVID-19 is a type of circumstance arising out of the same underlying cause, COVID-19, as the insured peril, such as the government action to lock down in the appropriate coverage clause. However, it is not clear whether this broad interpretation, which was given by the Supreme Court in relation to disease and hybrid clauses, will have an impact on coverage issues arising in relation to the in the vicinity clauses, which is found in the prevention of access clauses that were not decided, were only decided by the High Court and were not decided by the Supreme Court in the appeal. The second issue relates to the requirement of restrictions imposed on businesses in prevention of access and hybrid clauses, where the Supreme Court held that there was coverage for restrictions imposed by a competent authority due to an occurrence of COVID-19 resulting in an inability to use the insured premises, provided there was an instruction as understood by a reasonable person from a competent authority which carried an imminent threat of legal compulsion, or that meant that compliance was required without recourse to legal powers. Therefore, there was no requirement, according to the Supreme Court, that the instruction was legally binding as opposed to merely being understood by a reasonable person as requiring compliance. But what is still not clear is whether there is coverage for certain instructions imposed where there were only broad instructions by the government directed at the general public. For instance, statements by the government to the general public that individuals must keep 2 meters apart, the 2-meter rule, which are not restrictions aimed at a specific category of business. Finally, as regards the interpretation of manifestation of COVID-19, the third type of area of doubt, the Supreme Court held that an occurrence or manifestation of COVID-19 was proved wherever there was a person who displayed symptoms of or was diagnosed with COVID-19 within the specified radius. But what is not clear still is whether this broad interpretation may encompass a merely contactless travel through by a person through the geographical radius area. So the mere traveling through, is that enough to prove manifestation within the geographical area? So these are the 3 areas, namely trans clause, restrictions imposed, and third, manifestation of COVID-19, which are the 3 areas that are likely to require further clarification by the courts in future.